What's up, everybody? And welcome in to a weekend episode. We don't have a ton of these, but this one we're going to be dropping on the weekend because next week is the Crumbly sentencing on April 9th, just a few days from now. And there's been a lot of discussion ahead of that sentencing about what both sides are arguing for or asking for in sentencing. Now, it's always a situation where the defense asks for less time and the state asks for more. Defense will ask for probation or house arrest or things like that that seem offensive once their client's gotten convicted of a crime, especially a crime as heinous as this, gross negligence leading to the death of children. And they have been convicted of that involuntary manslaughter or accidental killing in their part and what they did in failing to stop, help, listen to, or do anything to prevent their son from committing these heinous acts. They've been convicted of that at this point. So that is a factual truth. And that's something they have to deal with when they ask for what the sentencing may be. And we know from other cases that the court takes all sorts of things into account: their previous criminal history, their remorse, them working on themselves, the previous time that they've already been in prison. Obviously, we know a lot of time served arguments happen at this point. And I think that the real factual scenario we're dealing with is not a lot of argument on what they've been convicted of, but what their sentence should be and what's a fair sentence for them individually in connection with the crimes they've been committed. They've been convicted of, is what I was looking for there. Because two people can be convicted of the same exact crime, and based on their prior history, prior crimes, prior actions, whatever they've done in their life, they can get very different sentences. Now, that's not necessarily going to happen in this case. I think it's pretty similar between husband and wife, especially with their backgrounds. But let's jump in now to some of the arguments that each side is making, because the lawyering in this case has been something. It's been really, really something, and it's not going to disappoint here for when we get to what Jennifer Crumbley's lawyer is asking for. So make sure you guys hit that like button if you haven't already. Make sure you subscribe to our page and join our membership crew if you guys want to get some behind the scenes stuff, some more vloggy type stuff, meet some other people in my life, talk through what it's like being in this weird vortex of YouTube and legal world and talking true crime and trials and things like that. If you guys want to join, all of that is in the description. So let's jump in now to the information on sentencing here. Jennifer Crumbley wants to live with her lawyer on house arrest instead of going to prison for her conviction in the mass shootings. But the prosecutors are urging the judge to give her 10 to 15 years. 15 is the max, arguing she has shown a chilling lack of remorse. So the first thing just can't go unnoticed. Jennifer Crumbley's lawyer, who has done some things that are a little strange, a little unique, a little different, which we don't hate on different and unique. And I like some, what am I looking for? Some interesting lawyering, some charismatic lawyering, some ways to think outside the box. I like that. I appreciate that. As long as it's in the rules, go for it, ask for it, fight for your client, be zealous. But to say that you want your client to live at your house on a tether, ankle monitor, whatever it may be, is a new one for me. Never have I done this before. Never could I ever see myself doing this. Never has my dad ever done this. We know her lawyer has kids, and she's going to have a convicted felon living in her house with her kids and take responsibility for watching over her. Now, things like this do happen. Defendants do get to go home in the custody of somebody, a priest, a boss, a family member, maybe even a lawyer. I can understand why this is not so far outside the bounds of reality, because things like this do happen where they are left in the custody of somebody and they sign off on them that they're going to be responsible for them. And maybe somebody bound by the rules of ethics and being a lawyer, maybe that's somebody seen as competent and capable of doing this. I have never heard of it. I have never done it. I would never do it. Now, I'm sure there are criminal defense attorneys that have done this in the past. Again, none of them work at my firm or have worked with or for my dad ever. But I guess it could happen. But again, this is as wild as some of the comments made and arguments made in her closing argument. So I don't know why we should be surprised at this point that she would make an outside the box request like this. Such a proposed sentence is a slap in the face, this is from the prosecutor, to the severity of the tragedy caused by Jennifer Crumbley's gross negligence to the victims and their families. She's trying to avoid prison, and new details have come out. Now, the Michigan sentence, what the unbiased investigation and pre-sentence investigation has told the court that they think the guidelines should be, which in most cases rules the day or is the thing the court takes most seriously. They look at the defendant's request, they look at the prosecutor's request, but this unbiased investigation looks at everything, puts it together, and gives a range. So what is that range? 43 to 86 months. So we know 48 months is 4 years and somewhere around 7 years. So basically somewhere around 4 to 7 years is what they think would be appropriate in this situation for Jennifer Crumbley. And from my perspective, I get it. I get where they would come to that. I think that's probably a fair range. Now, what's interesting about that is I think the Crumbleys have been in jail already for like 2 years. So 24 months of that ish, I think it's even more than that, are going to be cut from time served. And then if you talk about, the rule for good time and how early you can get out, there might not be that much more time left for them to serve in prison or in jail. Sometimes they just keep them in jail if it's not going to be for a long time to go through the processing and things like that, if it's just a few months. And then maybe she could get out on house arrest or some kind of probationary period with restrictions. That is actually possible. Whoops. That is actually possible. And the prosecutors just say this is not enough. And they have some arguments as to why this recommendation in the pre-sentence investigation may not be accurate. So this is for both parents, 43 to 86 months, which is also interesting that they have the same. I mean, I guess similar backgrounds and obviously similar actions in this case. 4 counts of involuntary manslaughter, each carries up to 15 years. But again, this is looking at a total sentence range of 43 to 86. And it's based on post-conviction interviews and facts of the case. Now, another thing we get here is some details about James Crumbleys' threats. Both the prosecution scoffed at the request and also requests that James Crumbley be sentenced to 10 to 15 years. So they're asking for the same thing, 10 to 15 years for each defendant. He also has a shameless lack of remorse and asking for time served as an appropriate sentence as a slap in the face of the severity. In calling for a stiff punishment, James Crumbley, Keast also said to see a prosecutor, cited multiple threats that he made from jail, including calling her an effing B and saying, your A is going down and you better be effing scared. So these are the comments made by James Crumbley about the prosecutor. Beyond the defendant's gross negligence, his jail calls show a total lack of remorse. He blames everyone but himself, and he threatened the elected prosecutor. He continues to blame everyone but himself. He considers himself a martyr. And in some of the calls, because I've read other quotes, he literally says, I know this is being recorded and I don't care. Very stupid to say those things as James Crumbley. They're coming back to bite him. Publicly, people are going to condemn him for those. I get being mad at the prosecutor. I get feeling like you're wrongfully charged. I get feeling like you're wrongfully convicted. But to say these things is overboard. And they can and should be used against you. And the court can and should consider them in his sentence. At trial, when I was asked if I was on the stand, Crumbley's trying to explain her own testimony. If I would have done anything different, I testified I would not have. And that is true without the benefit of hindsight that I know now, or that I have now. So she tries to clarify a little bit. Like now, obviously, with hindsight being 2020, maybe I would have gone back and done things different, but I didn't want to say that in front of a jury because they didn't want them to hold that against me. Well, you don't really get to clarify the facts in sentencing. With the information I have now, of course, my answer would be hugely different. There are so many things I would change if I could go back in time. But she didn't say that at trial. So can the judge really consider that? Probably shouldn't, but in reality, the judge can consider basically anything they want and can come into account because as long as it's within their discretion. I knew my son to be a quiet, good kid who loved pets. I never imagined he would hurt other people in the way that he did. I have been in jail for 26 months and have been locked down 23 hours per day. I'm hopeful the court will sentence me in a way that allows me to be released from jail for the balance of my sentence. The prosecutor urged Oakland County Circuit Court Judge Cheryl Matthews to exceed the state-determined sentencing guidelines and send her to prison for 10 to 15 years. So instead of the 43 to 86 months, push it higher, 10 to 15 years. Consistent with her efforts to minimize her culpability directly after the shooting, defendant now, even after trial, continues to show complete lack of remorse by minimizing any role she had in the matter. Demonstrating this fact, the defendant thinks a proportionate sentence is to be placed on a tether with house arrest at her attorney's guest house, ostensibly an upgraded residence from her former Oxford home where she resided before her gross negligence that led to the Oxford shooting. So she's saying, not only is she asking to go to her lawyer's house, and seemingly her lawyer's agreeing with this, which is the crazy part. It's not wild that Jennifer Crumbley would want to go there. And she's saying this is an upgrade. She gets to move into a nicer guest house at her lawyer's house than where she even used to live. So she got the come up from getting convicted. That's what the prosecutor's arguing, that the judge should consider. Keast, the assistant prosecutor, also portrayed Jennifer Crumbley as a liar with a drinking problem. And here's where they're saying the pre-sentence investigation had incorrect information, so you should discount their 43 to 86 month proposal. For example, the defendant reported in her pre-sentencing investigation report interview that she only used alcohol 1 to 2 times per week. That is a blatant lie. He included more than a dozen receipts for whiskey and vodka purchased over 1 month by the Crumbleys. He also stressed, beyond the defendant's lack of remorse, it is telling that she has no other support or ties left to the community, so she has to rely on her retained attorney for a proposed placement. Ouch. No family members or friend or clergy, like we talked about before, would take her in. It would be weird for a clergy to take her in, but sometimes I've seen, church, friends, counselor types, AA sponsor types willing to take criminal defendants in. That's all I can kind of see as an analogy here. But he's saying she's got none of them. She only has a lawyer she pays that's willing to take her in. They're basically just dragging her through the mud, which a lot of sentencing is, oh, they're really a good person, judge. Don't come down too hard on them. And the prosecutor saying, no, actually, they're bad people. Jennifer Crumbley's gross negligence changed an entire community forever. It resulted in the deaths of 4 students, 7 other individuals wounded, and hundreds of terrorized. The memo stated, adding that all of this could have been stopped with tragically simple actions from the defendant, but she failed to take any action when presented with the gravest of dangers, prioritizing her own convenience over the safety of everyone that day. The Crumbleys, who are the first parents in America to be held criminally responsible, by shooting carried out by their child, were convicted. Each count as 15 years. Both trials, prosecutors ignored mental health. Okay. So then they kind of get into the facts and arguments made at trial. But overall here, the defendants are asking for time served or house arrest, which is the just smallest and most minimal sentences you can get in a situation like this where you've been convicted of felony of involuntary manslaughter. And the prosecutors are basically asking for the max. I expect, if you want my guess as to what the judge is going to do, I expect the judge will end up somewhere in the 43 to 86 months. Why? Well, it's the easiest, right? It's the most protected on appeal, that it's less than what the prosecutor asked for, more than what the defense asked for, and right what the state recommendations are. So you're protected there, even though you do have judicial discretion to go above or below that. Also, it's kind of like splitting the baby. You're giving them more prison time than they're asking for, but with time served and good time as they continue to serve, it's probably not that harsh of a sentence and not that long that they'll be in there. They may ask to be released pending appeal because they'll probably end up serving. It's possible they could end up serving all or most of their sentence during the appellate process. But that just seems like the most reasonable to me. I'm sure a lot of you guys are going to say it should be 10 to 15 years. It should be closer to the max. And I understand that. What they've been convicted of and the results of that are as heinous and horrible as anything you can imagine. And I'd be totally fine if the judge sentenced them to 10 or 15 years because there's no more argument that they are not guilty. You have to realize that. I'm a proponent of presumption of innocence. I will push. Let's think. Let's make sure. Would we convict here? Would we not? How do we feel about this? Guilty, not guilty. But once they're convicted, and it is a proven legal fact that they committed these crimes and are responsible for those deaths, I get why people want 10 to 15 years. But if I had to guess what the judge is going to do, I would guess it's somewhere in the 43 to 86 month range. But let me know what you think in the comments. Let me know what your guess is, and not just what your guess is, but why. Let me know why you feel that way, because that's an important part. If you were the judge and you had discretion to make this decision, what decision would you make and why? Can't wait to read them later. Appreciate you guys joining me for this on a Saturday. Don't forget to hit that like button on your way out. Until next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a page you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.